On the record in the matter of Cheltenham Law versus James Burton, 25-01279. We're not able to resolve it. Is that correct?
That's correct.
Oh,
Sorry. Why am I answering? I'm so sorry.
it's how we have it.
Sorry.
That is correct. Your Honor, I call Colleen Cheltenham. It helps if I know how to pronounce my client's name to this day.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay, he can have a seat.
Are you familiar with Mr. Burton, James Burton, the defendant in this matter?
I am.
And how are you familiar with him?
Mr. Burton came to my office in, I think, April of 2022 and retained me as counsel.
Okay. And can you just walk through the routine process?
Sure. What we do first before we do retention is we meet the client and do a free consultation. I don't recall at the moment if that was in person or over the phone, but one of the two ways is how I met with James. And during that consultation, we discuss the case, we discuss maybe the process, and then our retainer fee and hourly rates. And then after that, we send a retainer fee agreement and electronic pay link to the potential client for them to sign at their will and then pay the pay link.
Very good. Handing you what is labeled as Plaintiff's Exhibit A. May I approach the witness, Your Honor?
You may.
Can you describe that document?
Certainly, this appears to be my retainer fee agreement with Mr. Burton.
As a Cheltenham Law, do you maintain business records?
We do maintain business.
Okay, and is the information contained in those records entered at or near the time of occurrence?
Yes, they are.
Oh, yeah, we'll undo that for now. And I apologize, Your Honor, I did not ask to approach. May I approach the witness?
Yes.
Does the court want me to ask to approach?
You're almost there anyways.
I was sort of thinking that, but I didn't want to say it out loud. So what are these invoices for? What do they represent?
They represent each and every time entry that either myself or my staff at the time entered in Mr. James Burton's.
And how does Mr. Burton receive these invoices?
He receives them in multiple ways. We send out this whole system, folder invoices in our all of the financials for a particular client. So once we enter our time, I create the invoice and I do the invoicing myself. Nobody else in my office is allowed to do this. So I create the invoice through my case, and it is submitted through my case into a link that the client would have to click on, open it, and view the document. I also submit it through my case via email. So they also send the client an email with the invoice. And I also send it sometimes, if I feel like the client needs a prompting, a text. So especially if it's a payment due. So through my case, there's a link within that system on the invoice. And if I click it, it sends a text as well.
Do you know, did you use all three with respect to Mr. Burton?
I did on multiple times. And I know that for sure because I reviewed my, the reporting for Mr. Burton in my case, and there's a history that gets attached to an email, and I can actually view the history. Gets attached to the invoice rather. So I can click on view history of one particular invoice, and it will tell me what date and time I sent the invoice. It will tell me what date and time the client viewed the invoice or viewed the link. Meaning that.
What objections had you received from Mr. Burton to the services outlined in the invoices you were providing?
I hadn't received any objection to the services, and I hadn't received any objection to the invoicing that they provided. It was only after that period of time, after the order was entered and after I sent, I'm sorry, probably going too far, but after I started communicating about collection work that I received objection.
You said after you started communicating about collection?
Yes.
Okay.
I had no further questions for this witness at this time.
Your Honor, if we may have 10 to 15 minutes to review the invoices with our client prior to cross-examination.
Absolutely.
This is the first we received.
Don't worry, it's off the record.
Okay, paragraph 21, please. Your attorney asked you about that. It says, this agreement and the terms of the engagement shall not be modified in any respect unless such modification is in writing and signed by both attorney and client, correct?
That's right.
So, isn't it a fact that it would be a breach of this agreement for you to ask Mr. Burton for $8,000 that's not in writing?
I don't understand the question.
Isn't it a fact when you asked Mr. Burton for an additional $8,000 beyond the retainer at the outset of this case, that would be a breach of that paragraph?
That is not correct.
That Mr. Burton never objected to these invoices. Isn't it true he objected when you demanded an additional $8,000 from him?
I'm going to object. You keep on saying that, but I've heard no testimony about the demand. She's not stated that she demanded, and there's been no testimony that
I'll ask then, Your Honor. Ms. Cheltenham, isn't it true that prior to the conclusion of the $8,000 payment plan arrangement, you asked Mr. Burton for an additional $8,000?
I don't recall asking him for an additional $8,000.
Isn't it true, Ms. Cheltenham, on December 9th of 2022, in a text message with Mr. Burton, you told him you owe the firm over $8,000, not just $1,000?
What was the date of the text message?
December 9th of 2022.
December 9th, 2022, and it does make sense. I would say you owe the firm about $8,000.
And isn't it true that you said not just $1,000, you owe the firm over $8,000?
Yes, that's it.
Isn't it true that Mr. Burton told you when he first started, you told him it would be $8,000 and he paid you $7,000 in payment and owes you $1,000 to make the $8,000?
That's what he said.
And then isn't it true he says, are you saying I owe you $8,000 more? And your response was, your retainer is $8,000. That's not what litigation costs.
I believe that's accurate.
Isn't it true he told you told me the entire cost would never go over $10,000?
That's what he said. Yes, that's what I recall.
Isn't it true you told him that?
I told him I didn't think it would go over that.
Isn't it true on December 9th of 2022, during this discussion, you also told Mr. Burton, quote, so if you're telling me you aren't paying your bill, you can stop contacting me right now, end quote?
Yes, that's what I told him.
You then told him you would be filing a motion to withdraw from the case next week, correct?
I believe so, yes.
And you didn't file a motion until February of 2023, though, correct?
That's probably correct. I was trying to get him time to pay the bill.
And isn't it true, Mr. Burton, in that message said to you, when I first talked to you, you did not want to say it will be $16,000 or more?
I don't remember his exact words, but I do recall that being something along those lines in the text message.
Isn't it also true he says, I don't think you're representing me right, I will find a new lawyer?
I believe he said that, yes.
Nothing further from this witness time.
Thank you. You can just go to page 1 of Exhibit A. It has the payment plan that indicates here's $1,000 per month to be paid. When should have that $8,000 been paid?
October 1 of 2022.
Okay, and that's before the text messages, correct?
Correct.
And I'm just curious, there's on almost every invoice, there's a number of items under category non-billable time entries. What are those?
Your Honor, I'm going to object. I believe that's outside the scope of redirect.
I'm just asking about another section in the invoices that he cross-examined.
I'll allow it. The objection's overruled.
Those non-billable time entries are time written off entries. So I think in almost every single one of Mr. Burton's invoices, I would write off time to assist with the cost of litigation. It says non-billable because there's a button I select in that time entry where you select non-billable. Non-billable time because we're not billing for that time entry on this invoice for a decision that I made.
It was identified that you did not file your motion to withdraw until February. And the text was from December. How long did you try to get a stipulation from defendant Mr. Burton prior to filing that motion?
I don't remember the exact time frame. I do know for sure that my paralegal at the time that had reached out to him after we drafted the motion. I know we sent it to him electronically to sign, and I know I reached out to Mr. Burton again before I filed the motion. So at least 3 different times I reached out to him to try to get him to sign a stipulation to withdraw.
I have no further questions, Your Honor.
Calling any witnesses.
Yes, Your Honor, I would call Mr. Burton. What was that case about?
It was about temporary guardianship for my daughter.
And why were you willing to pay $8,000 to Miss Cheltenham?
Because I love my daughter. I raised my daughter since she's been 3 years old.
Lastly, I think the other concern is there was never even a question about whether or not she represented him on a PPO. We asked him, did she defend him in a PPO? He says, no. This is the person that you brought to court to try to get the court to believe that the representation fell below the standard. Maybe if he had brought the new attorney in to maybe testify, if there was an objection to that, maybe that they could have discussed some deficiencies, but there's nothing that I see. I reviewed the billing. I don't see anything in here that would cause the court to believe that there was a deficiency in the representation, that there was neglect in timeliness of when things were filed, that when things went wrong or things were going a certain way, that Ms. Cheltenham, at least in the limited text messages I have, did not communicate this with the defendant. I see here, even in some of the description of the services provided, where there was communication, keeping him abreast of what was going on. And then there seems to be an abundance of charges that she wrote off to assist him. I'm not saying that the bill was meager, because this is definitely an expensive bill to have to pay this kind of money. And I don't know why, once he received a new attorney, the case was resolved within 2 court hearings. But just because the case was resolved within 2 court hearings does not indicate that the attorney that was previously on the case did not do their due diligence. It could have been an alley-oop. It could have been the case was worked up. You now have had the psychological evaluation that needed to have had. There was countless communications, which the court could see here, that was billed with the other party, with their attorneys, and negotiating and stipulating the things. And maybe the other attorney was able to come in and close the deal, and maybe the deal could have been closed just as quickly had there been a continuation of the services. That is for the defense to have established, and the defense has not provided me anything but some text messages that they believe hinged or showed the court that there was a demand. There was no demand here. There was a clarification that no, you have been billed monthly invoice, and you owe us over $8,000 at this point. And you've already breached. They didn't say this, I'm saying this. You already breached, because you should have already had paid, by the time they received this text message, should have already paid your $8,000 retainer. We've not yet received that. And then even in the latter communication in February, Mr. Burton is not, again, indicating that he doesn't want Ms. Cheltenham to represent him, and that he believes that Ms. Cheltenham services was not quality. He is operating in February as if he believes that he's still represented by her, which is a bit different. If you said here previously in December 9th that I don't want you representing me anymore, I'm going to get a new attorney. You said that in December. So why are you reaching out in February acting as if she's representing you? I also don't have anything that would support that he made these cash payments. That's the burden of the defense. If you are saying that he made these payments, then you got to give me something. And I don't know that his testimony is credible, because we asked him how he made the deposit. He told us it was in cash. He was adamant that it was in cash. He said, I had to ask him. I said, do you have any receipts, or did they give you a receipt? He said, yeah, I got a receipt. I said, did they give it to your attorney? Yeah, I gave it to my attorney. Only for the attorney to turn it over, and it is actually what the plaintiff said it was, which was not in cash, it was a Visa. And so if you can't even remember how you made that payment when you provided the receipt to your attorney, I can't now reasonably believe that you made some other payments that was not reflected, that you don't have any receipts for, because who's giving out $1,000 and not getting a receipt? I'm not giving anybody $1,000 cash. I don't care if you're an attorney or anybody, and you're not getting me a receipt immediately. And that you're getting paid in cash, and that you don't have a way to reflect with certainty that this is how you paid and these are the dates that you paid. That's not been properly pled or supported on this record, so I can't give you credit for that. So in this point, I have no choice but to give favor in judgment for the plaintiff in total $9,268.39.
Have a good weekend, Your Honor.
Have a good one. Thank you.
Have a good holiday weekend.